everyone. Welcome to my live show. It's attorney Laura Sterling. I want to thank you for tuning in. I want to thank you for being with me each week and every month when I do my live show, when we go over all kinds of different topics in regards to the legal field. Now, I always like to say at the beginning of my show, remember, I'm a Florida barred attorney. So if you're listening to me from another state or even another country, welcome, first of all. But know that I'm just licensed here in Florida. So I can't, how do I say this? I can't answer questions specific to your state or to your situation if you're not in Florida. If you're in Florida, I'm more than happy and more than welcome and honored to be answering your questions. And of course, if you have more specific questions that you don't really want to get into on my live show, which I understand, please feel free to call our office. Again, I would be honored to spend some time with you, sit down and go over your situation. Now, as you know, today is March 26th, and oh my goodness, we're already what? Into spring? How lovely. It's spring here in Florida, that's for sure. But, well, you know, I'm originally from northern Minnesota, and my parents sent me a picture. I'll have to post it on my Facebook. They sent me a picture of their yard. The snow is up to their waist, and I'm not lying. Can you believe that? It's March 26th, and they're still trying to dig themselves out. All summer, or I'm saying all winter, they haven't had much snow at all. If you watch my videos, I was there and there was barely anything on the ground, and I must have planned my trip accordingly to miss that snow, which, you know, I sometimes miss, but most of the time I do like my Florida weather. Anyway, I also wanted to take a few minutes just to kind of talk about what happened last, or I guess early this morning in Maryland, the boat that collided with the bridge, and then the bridge collapsed at like 1:30 this morning. I saw it this morning first thing when I woke up, and I wanted everybody to know that our hearts and prayers here at Trion Sterling are certainly going out with the families affected and the people affected. And please know that we're thinking about you, and we're sending our prayers and our strength up to you, and hoping that you can get through this, and that you have a good support circle that can help you as well. So I just wanted to take a moment and acknowledge those people. Okay, so well, today for our live show, as we've been talking about all month, parenting plans here in the state of Florida. Can you believe it? We're going to talk about it. Now, I'm only going to talk about a few segments of the parenting plan, because the parenting plan is pretty extensive here in Florida. And no matter what state you're from, you probably have some version of a parenting plan. A roadmap, as I like to call it, how the two of you are going to co-parent these children or this child or whatever. So that's what a parenting plan is. Now, I want you to be able to thoroughly enjoy the show and get out of it what you can and learn something, even if you learn one thing. I always feel if you learn one thing from reading or watching something, it's been beneficial. So I want you to be able to have your full focus on me. I used to teach at the university here, University of Central Florida, Go Knights. I used to teach there for many years, and I used to make my students right at the beginning of class, I'd say, okay, put down your phones. Your phones are no longer a part of class. If I see you with your phone, I'm going to take it. Now, of course, I'm not going to do that with you, but it's best to get your full attention and be engaged. And if you have questions, please let me know. So I want you to get comfortable. I want you to, either get your pen and paper or get your tablet with a writing instrument. And if you have questions, or if you have notes that you want to take and you have questions later on, like I said, we're here for you. That's what I'm here for, to be a part of what you need and answer your questions. So sit back, relax, watch, have your little water or your little soda or your tea or whatever. Have your little snacks if you want, your popcorn, your chips, whatever it may be. I really like chips. Anyway, but I'm not going to be eating during this, but just relax and take a moment to just listen to what we have to be, what we're going to be here today. We'll be here for about maybe 50 minutes, maybe 55 minutes, probably not quite an hour. But please, whatever your questions are regarding time sharing, parenting plans, bring them on. Just because I'm only talking about a few issues doesn't mean I'm more than happy to branch off from there. So parenting plans in Florida. What happens is a parenting plan is created whether you're in the process of a divorce, meaning you and your spouse are now going through a divorce in Florida. There's no real legal separation in Florida. You're either married or you're not. People come to me, well, I want to get a legal separation. Well, you have to go to another state because here in Florida, we don't do that. We do divorces. So if you're in the process of divorce, or it's a paternity case, a paternity where you were never married, but you have children in common and you're now separating. The parenting plan is crucial for creating a stable and nurturing environment for your child or for your children. So it kind of helps you to co-parent and maybe understand what you need to do. What is your job? What is the other person's job? Where are your children supposed to be? What do they need to be doing? What do you need to be doing? All of that is spelled out in the parenting plan. So let's dive right into that parenting plan with our noses plugged and our goggles on and our fins on so we can start talking about that parenting plan. What exactly is a parenting plan? Well, here in Florida, a parenting plan is a legal document outlining how parents will share responsibilities and make decisions regarding their children's upbringing. I know it seems kind of funny because when you're not divorcing or you're not asking for court intervention or you're together and you're raising your children, you just raise your children, right? You just do it. I remember when I brought my son home when he was a newborn, and we brought him home and I put him on the bed and I'm like, what do I do now? Like, I had no idea. What am I supposed to do now? When do I feed him? When do I change him? When do I bathe him? Is he going to grow? What is he going to eat? What is he going to wear? All of that stuff was very overwhelming to me. But what happens? You figure it out, right? You figure it out. Well, when you ask for court intervention, the Constitution says that the government cannot intervene in your parenting except when there's issues of abuse, abandonment, or neglect, or when you're separating and you're asking the court, hey, we need to divide this child. We need to decide what we're doing with this child. That's the time when the court can intervene. But otherwise, we're all just out there trying to make sure our children live. I remember one episode on Sex in the City. I love Sex in the City. Miranda and Steve had the child, and she gave the child. He was to watch the child, Brady, for the weekend, and she was going to leave and go to Las Vegas. And he leaves, and 2 minutes later, he is. And she's like, what? She opens the door, and there he is. And he's like, I can't take care of this baby. I don't know what to do. She says, no, wait. See, I'm not supposed to kill the child during the week, and you're not supposed to kill the child on the weekend. So that's how kind of we look at it when you're parenting a child. And you get so proud when they walk and they talk and they can do things on their own. When my child got his car, I was so excited. But a parenting plan kind of breaks down the necessities of child rearing, time sharing, medical, travel, extracurricular, what's school, the necessities. It doesn't cover the day-to-day decisions. That's you as a parent. You can do that. But it includes details about the time sharing, communication between you and your former spouse or partner, or you and the children, how major decisions affecting the child will be made. All like I say, it's kind of like a roadmap. On a roadmap, you're kind of figuring out where you're going. That's kind of what a parenting plan is. It's a roadmap of how to co-parent your children after you separate or after you divorce. So what are the legal requirements of a parenting plan here in Florida? Well, Florida law requires divorcing or separating parents to create this parenting plan as part of their divorce or paternity case. Now, I get people that come to me and say, oh, I just want to put on the parenting plan that as we agree, time sharing for Christmas, as we agree, traveling, as we agree, communication, as we agree. Well, you're separating or you're divorcing. And there's a reason for that. Maybe there's poor communication. Maybe you don't get along. Maybe you don't like the other person. Maybe they cheated, whatever. So what do you think when it says parties will agree? What if you don't agree? Then what happens? So I always tell my clients, I'm not putting as you agree because going to be a point where you don't agree. Think about it now when you're raising your children. There's a point when, even when you're married or with your partner, that you don't agree. So I always want to be very specific. The goal of the parenting plan is to ensure the child's best interests are prioritized. And both parents, I want to emphasize that, both parents have an active role in their child's life. There's no longer, at least here in the state of Florida, and I would assume in every other state in the union, there is no longer one parent has control over the child over the other. There's no primary, it used to be primary custody and secondary custody. What does that sound like to you? It sounds like one parent has more authority than the other, right? Mm-mm. Florida got rid of that several years ago and now says time sharing. Who does the child spend a majority of their time with? That's what we look at. That's it. We call it time sharing. My client would like time sharing every other weekend. My client would like time sharing every week, whatever it may be. We don't talk about my client's a primary parent. Nope, the courts will shut us down because that child is entitled to both parents. Again, both parents being equally involved in their life. That's in the best interest of the child. Here in Florida, the presumption has changed, as a matter of fact, and now we look at 50-50 time sharing. The presumption is you walk into that courtroom, let's say, and you're going to trial to try to figure out a parenting plan because the two of you couldn't figure one out. You couldn't get together and agree on anything. The first thing that court's going to do is 50-50. 50% with you, 50% with you. What's going on? Now, maybe one parent can't do 50-50. And I've had that before where a parent, I had one that was a long haul truck driver, maybe your work schedule, maybe distance that you couldn't do that 50-50, but it's an automatic 50-50. So, you really have to work together and you have to accept that. Now, like I said, the courts will automatically do that 50-50, whatever it may be. It may be 3 overnights, 4 overnight. It may be, breaking it up during the week. It may be Sunday to Sunday. I always try to encourage Sunday to Sunday because, when you're a child and you're trying to figure out, okay, where am I on Tuesdays? It's easier if it's, okay, Sundays, we're just going to do the drop off pickup, or Monday, Tuesday, whatever it is, to give that child that full week so they're not, going back and forth. So, that's kind of what we look at here in the state of Florida. Now, when we break down, like I said, the key components of a parenting plan, there's several things that are discussed in the parenting plan. Of course, like I said, the time sharing schedule. This outlines when the child will spend time with each parent, including weekends, holidays, and vacations. Summer is a big thing because here in Florida, the children get 10 weeks. They get 10 weeks. So what does that look like? Half with you, half with you. So it might be 1 week with one parent, 1 week the other. The courts don't really like 5 weeks with one parent unless they live quite a distance. Maybe they live out of state, or one lives in Miami, one lives in Tallahassee. Maybe they'll look at that, but they don't really like the child to be away from the other parent for too long. So if you split that summer 5 weeks, 5 weeks, the court may not be too keen on that unless you have a reason. Now, holidays. The major holidays are Thanksgiving, Christmas, spring break. Now, some people do celebrate other holidays. Maybe 4th of July is a big holiday for you. Maybe I'm trying to think about Labor Day or Memorial Day or something that's a holiday. So you want to kind of have those holidays. And of course, the court will work with you on that. Or if you have an agreement, if you guys can work it out, that would be fabulous. So, and then we roll into, like I spoke about before, communication. How are you going to communicate? How are you going to communicate with the other parent? Because you have to communicate with the other parent. I get clients that say, well, I don't want to talk to him. Oh, I don't want. You have to if you have children. There's no way you can get around not communicating with each other and have children. So if you don't want to speak to the other person, maybe it's texting. We're big into texting now, or emailing. Emailing is a little slower, but text messaging is a little better. Or what we have here, they have an app called Talking Parents, or another app that you can actually download on your phone. And it's very inexpensive, like maybe $4 a month or something. And you can communicate that way. Now, a lot of times I use Talking Parents, that app, when people want to keep track of what they're talking about, because as you're aware, in a text message, dates get lost and you're just showing times and all of that kind of stuff. But talking parents gives you a nice sequence, day from day, gives you a date, gives you a year, gives you a month, gives you a time. And so if you need to go to court for any reason, I'm not encouraging court, but if you had to go to court for any reason, you have that there for you. So, how are you going to communicate with the other parent? Maybe you have fabulous communication and you can just do it any means. And also, how are you going to communicate with the children when they're not with you? And understanding that they may not always be available. I know my 25-year-old son, I can call him every day. He does not pick up. One day he does, usually when he needs something, he'll pick up the phone. Now, do I fuss and fight about that? I've learned to accept it. I've learned to deal with it. So we know that our children are busy. As they get older, they're in extracurriculars or have friends or doing all that kind of stuff. So what I like to do with my clients is set a time, a day and time. Maybe it's every day at 7, or maybe it's every day at 8, that, hey, you get to talk to your child. And if you have a small child, 2, 3 years old, how long do you think they're really going to be on the phone or FaceTime or whatever it may be? You may get a couple minutes out of them and poof, they're gone. So also you get the ability to not have the telephone conversations supervised, the other parent kind of listening in. No, that telephone conference should be private between you and your children or your child. So it does spell out communication. Then relocation. Now, there's a whole statute here in Florida, and generally all in the United States, there's a relocation statute. If you move more than 50 miles away from your last residence per the last order, that you need to file a petition to relocate. The parenting plan, if the petition to relocate is accepted and agreed upon or even ruled on, that parenting plan has to be completely redone. Because like I said, oh, you lived together in Miami, oh, and then you moved only a few blocks apart so you could co-parent this child, but you got a really good job offer. Now you're moving to Tallahassee. Well, that's more than 50 miles away. So now that parenting plan is going to change in the time sharing. So the parenting plan addresses relocation. Now, you may wonder how to create a parenting plan in Florida. It's recommended that parents work together to develop a plan that suits your circumstances. I mean, you know what you want, you know what you need, you know what you can handle, you know what you can't handle. And it's best to, I tell my clients, to come to an agreement on time sharing, because otherwise, guess what you're doing? You're going in front of a stranger in a black robe. They don't know anything about you. They know nothing about you. And they're just going to rule based on the law and what evidence are given. And one person may not be telling 100% of the truth. I know that's hard to believe. And the other person may. And then you get something that you're not happy with. So I always encourage them, my clients, to agree. But of course, if they can't, or the other side is being unreasonable, I say go to court. So, hi, Will. How are you? Hello, Miss Sterling. I'm moving about 30 minutes of my current home. On the parenting plan, it says that mom's home is primary residence. Oh, you must have a, it probably doesn't. And I don't know when you did your parenting plan, Will. It may not say primary residence. It just may say that she's designated as the legal address of the child, because the child has to have a legal address. They have to, for school purposes, for mailing purposes, all that. That does not mean that she has primary residence. It's just you're using that for maybe school purposes and legal purposes. Mom's home is primary residence, but the address of dad will be used for school district. There you go. Once I sell the house and move, will my new residence be used for school district, or will it then be void because the address has changed from the original address during the divorce? Thanks. That is an excellent question, Will, because I do get that a lot, where people are moving. Well, it says it's designating my school district, but generally, and Will, you tell me if I'm wrong, there's also, you're putting in what county. So let's say, like I'm in Seminole County. So it would be, we're following the Seminole County schools, and mom's address is going to be the address for school purposes. So if you move to a different county, then yeah, mom can say, wait a minute. I don't want to uproot my child, our child, never say my child, our child and have them go to a totally different school district when we said in our parenting plan we were designating Seminole County and designating my address. So she could bring it up to court. Now, if you two can agree and say, okay, I'm taking the child with me, and so we're going to change school districts, understand that's a shared parental responsibility. And we're going to talk about that. That's something you need to talk about, changing the child's school, because that's a big thing for a child to have to change schools, no matter what age they are. They could be a teenager, they could be a small child. Change is hard for anybody. So that might be something that you want to talk about with her. And I don't know if you have and what she says about it or what you said about it. And so, make sure that you kind of get that together and get that kind of worked out. If you can't work it out, if she's dead set about the child staying in the school district outside of where you are, then you may need to file something to get that changed. And I don't know if 30 minutes, if you're saying you're 30 minutes away from your prior residence, if that's 50 miles from your current resident. If it is, then you're going to need to file a petition to relocate. And how we calculate the 50-mile mark is take your address as a crow flies to your new address, not MapQuest, not Google Map, because again, you're kind of doing this on Google Maps. So, but we're looking as the crow flies as a straight shot. So you might want to check that out. I one time had a judge tell me, God bless him. He said, well, Miss Sterling, what I do is I take the courthouse and I map out 50 miles. I said, oh, no. I go, Your Honor, that's not the statute. The statute is 50 miles from your last residence. So you might want to check in all those. And I'd be more than happy to help you if you want to give us a call. So, but excellent question. I get that all the time. So, two, I want to address that as well. If you can't reach an agreement by yourself, there's always something we use in court called mediation. Mediation is where, you go, if you have an attorney, there's a neutral third party there called a mediator that can assist in facilitating all these issues with a parenting plan. And also, making sure that you get legal advice to make sure that, you follow what the law is and getting that parenting plan taken care of. I can't tell you how many times I've had people come to me that have done their own parenting plans, never consulted an attorney, and it's really not good. I have one right now that's really not good. And they just agreed to it themselves. He just signed off, and now it's created a whole host of problems for him. So just always make sure to get legal advice when you're dealing with a parenting plan. Now, the first little subset of a parenting plan that I want to spend some time on is extracurricular activities. What does that mean? These provisions in the parenting plan can help clarify how such activities will be handled and shared between the parents. Now, there are some considerations regarding extracurricular. I always say it fast. So, I used to have a lisp as a child. So, excuse me on that. Some considerations regarding extracurricular activities in a parenting plan in Florida include what activities are we going to include? I mean, are we including everything? Some people talk like aftercare. Well, I don't think aftercare is an extracurricular activity. But hey, if you guys agree it is, it is. But what types of extracurricular activities are included? Is it sports? Is it arts? Is it music? Is it academic clubs? Is it band? Is it the debate club? Just to let you know, I was on the debate club in high school. I know you can't tell. Whatever it is, you need to identify what those extracurriculars are. And then who has the authority to enroll the children or the child in those extracurriculars? Now, generally, what we do is we generally put in the parenting plan, both parties have to agree. They both have to agree on what activities there are. Because guess what? There's a split of how you're going to pay for them. Not one parent is solely responsible to pay for these extracurriculars. There's usually either a 50-50 split, mom pays 50%, dad pays 50%, or what we like to call pro rata, meaning we do the child support calculation, whatever dad's percentage is, that he has to pay of child support, and whatever mom's percentage is of support, that's how we divide it. So that could be 70-30, 60-40, whatever it may be. And that's how they divide. So it's one of two ways. Now, let's say you don't agree. Let's say mom calls you up and says, I want to enroll Jimmy in piano. It's $700 a month. And you're like, oh my God, I can't afford that. I can't afford, what is that, $350 a month? I can't. I don't agree. You have the right to do that, because when we put the clause in there that both parties have to agree, and if one party goes ahead and just registers them against your objection, then that person who enrolled them is 100% responsible. So if I go ahead and I enroll little Jimmy in piano and you said, no, 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 I can't afford it. I can't. I'm paying child support. I'm paying this. I'm paying rent. I'm paying all that. I just can't afford it right now. But I go ahead and do it myself, then I'm going to be responsible to pay that. So also another issue is how are you both going to communicate what's coming up? Sports games, recitals, performances, shows, all of that. How are you going to communicate that? And generally, both parents should be on the communication list for the school, should know 100% about them. And that, but sometimes they don't. So it might be sharing schedules, making an extra copy of a schedule, sending it with the child to give to the other parent, or giving it to themselves. Any registration deadlines, anything like that that may be associated with it. Also, there's transportation arrangements. Who's going to drive the child? What about if the child's with dad and dad only gets them on the weekend, and there's an activity that the child has on dad's weekend that's associated with this extracurricular? Does dad just go, oh, well, too bad, so sad, child, you're not going to your activity? No, that whoever has the child, this is something you put in the parenting plan, whoever has the child would transport that child to their extracurricular. You don't want the child to suffer because the parents are no longer together. Sorry, little Jimmy, you can't go to your little football game Friday night because I have you and I'm not taking you to the football game. No, there needs to be that whole agreement. And then also, how are you going to deal with uniforms? Oh, that's always a fun one. Uniforms or anything else that's associated with it. Does dad keep some at his house? Does mom keep some at her house? Does the child take it back and forth? Whatever it may be, that should also be spelled out. And the location should be attendance and participation, address expectation regarding the child's activities and participation, and how any conflicts may come up. How can you resolve? And if that child missed an activity, how do you make it up? Also, how are you going to coordinate as parents to make sure that the child gets there? Again, communication, whether it be by text, app, or just communicating between each other. And maybe you have a conflict. Dad has a conflict. Hey, this weekend I know I have them, but Friday night I was working until 8 o'clock. Can you take little Jimmy to his football game? And so being open to that and not just saying, no, I'm not doing it. You got to remember, you got to love your child more than you maybe dislike each other. So thinking about, okay, I need to think about what's best for Jimmy. Okay, let me work with him, even though I'm not too happy about working with him, but let me work with him about the best interest of the child. And always knowing that being flexible, modifications, that the child always comes first and the court looks at it as the best interest of the child. So extracurriculars are always kind of something that are discussed. They always want to know what the definition of an extracurricular activity is. I find that children nowadays are in more extracurriculars than I ever was in. It was easy peasy. I didn't need any transportation. I just hopped the bus and the bus would take me home after my extracurricular, whether it be cross country, yearbook, whatever it may be. So just knowing that you need to work together and coming to that agreement and making sure that you're co-parenting for the best interest of the child. Ooh, okay. Our next little element is going to be decision making. And Will, this is one thing that was good for you, is decision making. There has to be decision making authority, because now you're more or less a single parent. You're going to have this child with you where you don't have the other parent, or you don't have the contribution of the other parent to be able to go to that other parent or to just defer to that other parent. You need to make decisions. And so the day-to-day decision making, that really is not, the court's not going to get all involved as to whether or not little Jimmy stayed overnight at John's house or whatever. That's really, as a parent, those are the kind of decisions you should make on a day-to-day basis. But the actual important decision making, those decisions typically include matters such as education, healthcare, religion. I've had a few where religion has actually been a hot topic. I had one that was, what do you call them again? Jehovah's Witness. And then another one who's Christian. And they're very on way different spectrums, right? Jehovah's Witnesses, they don't celebrate any holidays. Christians, they celebrate holidays. And it was quite a little fight there for a while. And they wouldn't agree. They would not agree on how to incorporate both religions into these children's lives. So we ended up going in front of the judge. And the judge said, this is exactly what the judge did. And I'm not saying this is what a judge would do in every case, but when the child was with mom, the child celebrated those issues or dealt with those issues regarding Jehovah's Witness. When the children were with dad, they celebrated those Christian traditions. They celebrated Christmas. They did all of those kind of things. So it was almost like they got the best of both worlds. They got to see how it was for both and then potentially make their own decision if they want to when they get older. So, like I said, these decisions are not these everyday decisions. What's Jimmy going to wear to school? What's Susie going to take to lunch? It's really more about education, where they're going to school, what kind of school are they going to, healthcare, what kind of surgery, if they need some surgery or they need braces or they need glasses. Those are the kind of things that you should do jointly, co-parent with. Religion. For some people, religion is not really a big thing, but for some it is. So we need to keep those in mind. Hi, James. How are you? I will soon be divorcing from my wife. Well, I'm sorry to hear that. And we can't agree on a custody agreement. We call it a parenting plan now, time sharing agreement. I suggested me going to a 4-day work week. Oh, look at you. And having custody Friday through Sunday. So I'm assuming you're meaning Friday night to Sunday night. She would have Monday. I'm assuming like you would drop the child off, let's say Sunday night at mom's house or wherever you drop off. And then mom would have, wake up Monday morning, take the child to school, and then have until Thursday or till Friday morning, and then you take Friday. I'm assuming that's what you mean. I also added a full week of time sharing for each of us for a vacation. Perfect. We do that. We sometimes do 2 weeks because, nowadays traveling and stuff, it takes a while. And those are usually in the summer. I'm assuming you want it in the summer. She feels it's unfair. I have every weekend. I really need help for figuring out a fair custody agreement that works for everyone. I do see that sometimes where with your work schedule, you can't do during the week. You can only do during the weekends. And sometimes the parent who doesn't get the weekends, they want a weekend too, because guess what they end up being? The homework, the school, the laundry, the dinner, the bathing, and that's all they get. And so they want at least a weekend to, hey, let's go here in Florida. Let's go to Disney or let's go to the beach or let's go to the movie. They get to do that thing. So I can see kind of, she's maybe if you want to think about one weekend a month you give her, maybe you make up for it like an overnight during that week, during the week or something. Maybe that's something that you can kind of negotiate. The court, if you can negotiate an appropriate and reasonable parenting plan that's in the best interest of your children, the court will go for that. I mean, as long as the child is not a long time away from the other parent, if there's not a distance. I watched a couple get divorced. I was waiting for my case to be called, and they had a parenting plan and they seemed to get along well. They both went up there together. They seemed very united, which was great. And they put down that one parent would have the child for 30 days, nonstop, 30 days. And then the other parent would have the child 30 days nonstop, no interruption. The judge went, no, no, no. She was like 8 years old. The judge was like, no, that's not in the best interest of the child. An 8-year-old needs to have more contact with both parents. Going for a 30-day stretch is just really not in the best interest of the child. And that's what the judge said. And the judge said, listen, I'm here all morning. If you want to go on the back and you want to come up with a better arrangement, I'm more than happy to listen to it. But she didn't want them to go for such a long time. So it sounds like you have a good schedule, James. Maybe, I mean, that's up to you. And you may want to seek legal advice, is maybe giving up a weekend, one weekend, but taking a couple extra days maybe during the month where you can have the child overnight to make up for that. Because like I said, your wife may want at least one weekend to at least have time, just downtime with the child, rather than, we all know with our children, we're racing like a banshee during the week. And then on the weekend, we're probably racing some more to all their activities, but at least you get a little more downtime. So good question, James. And if you need any help, we're here for you. So just let us know. And again, I'm sorry going through divorce. I know it can be very hectic. So, but anyway, okay. So decision making. So well, the first one I like to talk about is sole decision making. That means one parent makes all the decisions, all the major decisions. You cannot switch schools without getting permission from this parent. You cannot make any healthcare decisions you cannot do anything without this parent. This parent is the sole decision making. Now, again, you can make everyday decisions. We're not talking about that. We're talking about major decisions, healthcare, religion, school, all of that. Sole decision making. That's a very rare occurrence here in Florida, because really both parents should be majorly involved with these children, and one parent should not have the sole authority. I think in my 19 years, yes, 19 years of practice, that I've only had, that I can recall, two cases where the judge ordered sole parental responsibility when there was another parent involved, meaning when two parents were involved in the case. I only had two cases where there was granted sole parental decision making for one. Now I get a lot of sole decision making when the other parent doesn't show, or doesn't even show up for court, or doesn't even participate in the proceedings. And yes, I can get sole parental responsibility or sole decision making, but I've only had it twice where the other parent was involved, and those were pretty egregious situations. There were substance abuse and anyway, just different things that took into account the reason why the court made it sole decision making. When a court makes a finding of sole decision making for one parent, they have to put findings in the final judgment. What are findings? Findings are their legal reasons for granting that sole parental decision making, because that's a huge leap to take a parent's decision making ability away from them. So the courts have to make sure that they include that in the final judgment so that they're covered. Oh, another reason why what do I want to say? I get a lot of sole decision making when the other parent isn't involved, is when one parent is here and the other parent, they don't know where they are, they've taken off, or whatever has happened, and that parent needs to get a passport. Because as you know, you need both parents to get a passport up until the age of 16, 15 or 16. Then you only need one parent. But you need both parents. The Department of State does not care what your situation is. They want a court order that says you have sole decision-making ability. Then they'll give you a passport. So I get that a lot with some of my clients where the other parent is not involved. So the next decision-making ability is called shared parental responsibility, or joint decision-making, meaning both parents share the responsibility for making major decisions regarding the children's upbringing. You both have to communicate. You both have to make decisions. One parent can't unilaterally take a child from one school and put them in another school. They cannot. That's a joint decision. That's shared parental, because That's uprooting the child. That's a major decision when you move a child from one school to the other. Believe me, I moved a couple times. I know how it is. I know how it feels to have to be moving schools. And it can be very traumatic for the child. So that's why the court says, this agreement, this shared parental responsibility requires cooperation and communication between the parents to reach an agreement on important matters that regarding their child. It kind of forces you to co-parent. You have to co-parent. The court's saying you got to co-parent. You both brought this child into the world. You both have to co-parent this child. So, and what the court looks at when they decide who's going to make decisions or how decisions are going to be made, again, what's in the best interest of the children. They don't care about mom. They don't care about dad. They don't care about how mom says dad this or dad says mom this. They care about the best interest of the children. And hi, Courtney. Hello, Attorney Sterling. My question is, what is the best way to address holidays in a parenting plan? You guys have such good questions. Thank you. Let me tell you, holidays, we do them several different ways. They either split the holiday, like let's say Thanksgiving, let's say the children get off Friday before Thanksgiving. So that gives them about 10 days. Okay, maybe one parent has the first half, one parent has the second half, which includes Thanksgiving. And then the next year they rotate it, so they're always rotating. Or maybe you actually split Thanksgiving, which may be kind of crazy because you think about it. If your child is splitting time with dad in the morning for Thanksgiving, blah, 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 blah. Then they go with mom in the afternoon. I don't know, but maybe the child likes it that way. So there's that way. Christmas, a lot of times we say, okay, one parent has the first half, one parent has the second half. Then you rotate the next year. So one parent has Christmas Eve and Christmas Day the first year, and the other parent has New Year's Eve and New Year's Day that year. And then the following year it switches. So the one that had New Year's Eve, New Year's Day, they now have Christmas Eve, Christmas Day, and the other one has New Year's Eve and New Year's Day. Or you split Christmas Eve and Christmas Day. And as I tell my parents all the time, do you think your children care about how many Christmases they have? Not in the least. As long as they're getting presents, they'll be like, yeah, we'll go to mom's in the afternoon and dad's in the morning. No problem whatsoever. So it's up to you. If you two, like I said, can come together in a mediation and agree and feel comfortable with it, then hey, however you look at it, thinking of what you have to do and thinking about what your child has to do, or if you go in front of the courts are going to split them. They're going to split them because they want that child to have equal time with both parents. So very good question, Courtney. And again, if you're having issues with it or anything, we're here for you. So anyway, so the factors that may influence the court's decisions regarding who's going to make decisions and in the statute, there's I think it's subdivision A through Q. I think it's A through Q. I'll have to check that. I would be pretty impressed. A through Q of factors that the court looks at when they're determining decision-making and time sharing. Just a few of them can include, how each parent can take care of the child's physical and mental well-being, the relationship between the child and the parent. Here's a big one, and I'm going to say this a couple times. The willingness of each parent to encourage a loving and caring relationship between the child and the other parent. Are you going to encourage that child? Hey, your dad's on the phone. Here, talk to him. Hey, you're going to your dad's today. That's fabulous. That's great. I'm glad you have so much fun when you go there. Is to encourage that relationship, as long as it's not a negative relationship or a toxic relationship, that they encourage that loving relationship. Because I get a lot of times where the other parent is like, I don't want them to have anything to do with the child. And the parent hasn't done anything wrong. They just don't want the other parent to be involved. It's almost like the child is their possession. And I don't like that. That child came into their world without any choice. You two chose to have that child. That child came in without a choice. So that child should be shared equally. That child didn't choose you as parents. You chose that child, but that child didn't choose you as parents. So encouraging that relationship and encouraging that bond and making sure that both parents are involved, that will make sure that your child comes out as well as to be expected. Comes out with being ahead of the game rather than behind the game. You can tell I feel very strongly about this. Anyway, and then any history of domestic violence or substance abuse or any other issues that may impact the child's safety and well-being. So if you've got somebody that has a history of drug abuse, and I've had cases like that before, history of drug abuse, domestic violence with the child or in front of the child, those kind of things could really sway the court into saying, we want to protect the child. That's the goal of the court, is to protect that child and make sure that child is taken care of. And they want to make sure that they know everything. Okay, has there been domestic violence? Has there been substance abuse? Has there been anything that may be harmful to that child? So those are just a couple of the factors. There's so many more, and the statute really just goes into it. And that's why it's always best to seek legal counsel when you're coming to an agreement. But hopefully you can continue to come to that agreement. Now, our next thing that is addressed in a parenting plan is uncovered medical expenses. Now, I pay the health insurance, so I should get half. You're covering the health insurance. Let's say you're doing it through your employer and you're paying, let's say $200, which is a joke, right? It's way more than 200, but let's say you're paying $200 a month. $100 is just for you, just to cover you. The extra 100 is to pay for the child. That extra 100 actually gets put into the child support worksheet. So actually, the other parent is technically helping you with that by paying just a little bit extra in child support towards that health insurance. So we don't generally count health insurance as uncovered medical expenses because that's covered in the child support. What we consider uncovered medical expenses are the ever so lovely, the ever so wonderful braces, co-pays, eyeglasses, whatever it may be, medications, whatever it may be, where you're going into your pocket, either at the doctor's office, at the dental office, at the orthopedic, whatever it may be that you're coming out of pocket for, that is what uncovered medical is. Now, I'm going to tell you right now that uncovered medical, I've litigated many a times braces. I don't know why. I don't know why it's such an issue. Braces, because suddenly the other parent who doesn't want to pay whatever their percentage is of those braces suddenly becomes an orthodontist. And they're like, oh, no, they don't need braces. And we litigate because you're not an orthodontist, you're not a dentist, you don't know whether or not they need braces or not. I have a professional who's an orthodontist or whoever they may be that says they do. So, but anyway, braces can be quite pricey. I mean, luckily my husband's a dentist, so we got our braces for our son dirt cheap, but I know that braces can be pricey. And I know a lot of the orthodontist office do payment plans and stuff. And so when you're talking about uncovered and how you have to share those expenses, they can be just like with the extracurricular. They can be 50-50, or they can be pro rata per the child support guidelines, 70-30, 60-40, whatever it may be. So that's the same thing here. You're going to be responsible for whatever half it is. Now, generally, sometimes we get a little fancy in parenting plans and we say, okay, if the uncovered medical is over $500, it needs to be discussed. That's a shared parental responsibility discussion, decision-making ability, because yes, braces can be very expensive. So let's talk about it. How can we afford to get our child braces? Maybe it's a payment plan. Maybe it's we pay a little bit now, a little bit later, or we start pulling money together to get our child braces. Or one parent pays the entire bill. I wouldn't advise that. And they get repayment from the other parent, or you both are paying your share to the provider. Whether or not the provider allows that, that's really going to be up to the provider. But anything uncovered is anything not covered by insurance. Like I said, copays. Now, a lot of times my my clients like a $20 copay or something, they don't really sweat about that. It's when it gets to be a little bit more and they're having to shell out. I've had clients that have been in, therapy for different ailments and stuff and are paying, out of pocket a large amount for this therapy, and the other party is responsible for that because it doesn't just include medical. I always make sure medical, dental, psychological, orthopedic, whatever it may be. I make sure to include that because people like to think medical expenses are just, I'm sick. That's a medical expense, but that's not the case. Hi, Amanda. Oh my gosh, what a beautiful family. Look at those children. They must be twins. They look like twins to me. But hello, Attorney Sterling. I'm going back to mediation soon, hopefully. Good for you. I'd like to know in your experience, in my experience, what things in the plan are a waste of time and what things are important to include. Thanks. Really, everything is important to include because the parenting plan here in Florida, you can just go through it. It just gives you kind of a guide as to what you need to do. Now, one thing that's not covered in the parenting plan that I always write in, there's a little spot at the very end that says other, uncovered medical, because that's not covered in the parenting plan, and who's claiming the children on their taxes. That's always a big one. So I always, write that in there if we can come to an agreement. So I would say, Amanda, I think everything that you feel is important is important. Everything that the other parent feels is important is important. So I would include, because like I said, down the road, when you're not agreeing to things or you're not seeing eye to eye, having included all that stuff will help you, will be beneficial in the long run. If you don't put it, then now you've got a dispute. Can't make an agreement. You can't agree to things because you didn't put it in there. But you can have this glorified, this wonderful parenting plan. But if you guys kind of want to skew off of a little bit as you agree, okay. But it at least is a fallback to if you don't agree. So that's would be my advice to you, Amanda. But excellent question, and good luck at mediation. So I hope that it works out for you. So anyway, so as we talked about, uncovered medical expenses, our deductibles, copays, medications, treatments, therapies, dental care, vision care, anything not covered by insurance. Again, we allot the expenses either 50-50 or pro rata per the child support guidelines, whatever your percentage is, and then how it's paid. Usually we do, okay, if one parent pays it, they have to present that bill to the other parent within 30 days. You can't wait a year and say, oh, hey, look, I got this. I want to give it to you. No, that you have a certain amount of time to present it to the other parent. And then the other parent has a certain amount of time to either pay you directly or pay the provider. So, and then like we talked about, getting consent for uncovered medical. If it reaches over a certain amount, maybe you're okay with 500, maybe you're not okay with 500, maybe you wanted 200, whatever it may be, that you guys have an agreement in regards to that. So, and then of course, if there's a disagreement, how are you going to resolve that disagreement? Are you going to go to mediation? Are you going to, file something immediately in court? Courts always like you to see if you can work it out and then come to us. If you can't work it out, then okay, then come and get court intervention. But trying to see if you can work it out first. And then who is going to be covering the child under health insurance? Is it going to be dad? Is it going to be mom? Who is it going to be? And is it reasonable? If I have to pay $2,000 a month for health insurance, is that reasonable? Probably not. Maybe there's Medicaid, kid care, whatever they may be. Maybe that is something that you can look at. Now, when we do a parenting plan and sign it off and get a court order and all that, does that mean it's the end all be all? No. There is always modification. Like my gentleman was talking about at first, hey, I'm going to be moving. What should I do? If you need to do a modification, first approach the other parent if you have a good relationship. See if they'd be agreeable to a modification. If they're not, then you potentially have to file what we call a supplemental petition to modify, saying, hey, there's been a significant change in circumstance since this original parenting plan was drafted. And so we want to make changes to it. I want to make changes. It's just like a brand new case, but it's just dealing with the parenting plan, just what's going to go on now that you're moving away or whatever it may be. So just know that you can that you can change it and that it is something that is in the best interest of the child still. So I hope I answered all your questions. I know it's kind of a lot of information and I didn't even give you everything. This is just a portion of what's included on the parenting plan. But understand that creating a parenting plan in Florida is crucial for you guys to co-parent so you can provide stability and support for your children. Open communication, flexibility, and a focus on the child. I see a lot of times in these cases, divorce or separation, that they're really not, they're more thinking about themselves and they're not thinking about the child. Think about the child. Think about the child. Take yourself outside of yourself and look at the child. And you want your child to be successful and you want them to be happy. And for that is to make sure that two parents that want to co-parent can co-parent together. So please, if you found this information helpful, please give us a call. We'd be more than happy to talk to you, be more than happy to sit down with you and go over your parenting plan, or if you're about to go through a divorce or a paternity case or a separation, we'd be more than happy to help you. I want to thank you for joining me here on my live show, my live Facebook. Know that I'm also on YouTube. I also do a blog. I do, what do you call it, podcast. I'm all over the place. So make sure you stay tuned. Now, next month, I want to give you a little prequel. Next month, we're going to talk about, kind of keeping with the theme of agreements, we're going to talk about marital settlement agreements. Marital settlement agreement is where you talk about and try to come to an agreement about the distribution of your assets and liabilities in your marriage and how that's going to be divided, alimony, anything like that. So we'll talk about that April 23rd at 2 o'clock in my live. And I hope to see you there and have a beautiful rest of your week.